Hi, this is Dan Breen from Breen Goril Law in Chicago. My firm concentrates in plaintiff personal injury litigation. I'm here today to talk about referral fees. I'd like to discuss three things today. What are the important rules to consider when you send a case to another lawyer with the expectation of receiving a referral fee to ensure that you're both ethically compliant and that your interest in that case is protected? Second, I'd like to talk about some of the important risks and pitfalls to be aware of when referring a case out. Last, we'll talk about some best practices briefly to make sure that everything you're doing is as good as it can possibly be. So maybe you're a defense lawyer or family law attorney. You come back to your office in the morning after court and an old client calls. This client's been in a car crash, they're out of the hospital, but they still need medical treatment and certainly need some legal advice. You know enough to know that your expertise lies elsewhere, so this isn't a case you'll be taking. But you also know that if the referral is handled appropriately, there's money to be made off this situation. So you call up an office like mine that concentrates in injury cases. The rule that governs referral fees and fee splitting between lawyers is Rule 1.5e. Rule 1.5e, in the context of referrals, says that in order for lawyers to share a fee on a case, both lawyers must assume joint financial responsibility for the representation, and the fee arrangement must be in writing and signed off on by the client, including the fee share that each lawyer is expected to receive. It's easy to assume that when you take a case in and refer it out, and that's the lion's share of the involvement you're going to have in the case, there's easy money to be made. However, there are some important risks and pitfalls to consider before sending a case out and thinking that you'll just be expecting a payday when that case is concluded. The first one of these is the joint financial responsibility that we talked about. When you send a case out or refer a case out with the expectation of receiving a fee, in order to be entitled to that fee, you assume joint financial responsibility, meaning that if anything goes wrong with that case, you'll be responsible just in the same way as you would if it was a case that you'd handled all on your own. It's also important to think about how accepting a referral fee could open you up to a potential conflict of interest. This is particularly important for attorneys that work at larger firms who often represent insurance companies or big corporations, entities that often end up as defendants in these types of cases. A fee, even on a potentially significant case, could pale in comparison to a lifetime of business down the road. So what are some of the best practices to implement to ensure that you can both rest easy and make money on cases that you decide to refer out? The single most important piece of advice that I have for you in this regard is to cultivate a strong relationship with the referring attorney. This will take care of many of the problems that would otherwise crop up, and it'll make discussing updates on ongoing cases that much easier. So when you send a case out to another lawyer, always make sure that your name is on the retainer agreement and that the fee split is broken down explicitly on that retainer agreement that'll be signed by the client. Likewise, you also want to make sure that your name or your firm's name is on the settlement statement when the case closes. And lastly, if you're ever unsure about the best way to proceed in this realm, as long as you err on the side of full disclosure in writing, you're pretty certain to be safe here. For more information on referral fees, please view my full CLE presentation, recorded during the ISBA Solo and Small Firm Practice Institute program, Propelling Your Practice to Prosperity, available in the ISBA Online CLE archives.